the most common mistakes made in real estate contracts and how to avoid them. Hey, I'm Aaron Griffiths from Onsite Law, and in this video we're going to break down the most common mistakes we see in real estate contracts in Queensland that lead to delays in settlement and increased costs to all the parties. The most common error we are still seeing in contracts at the moment is incorrect spelling of party names. This could be avoided through a simple ID check to ensure that not only are the names spelled correctly, but that middle names are also included on the contract. Not having the correct details can cause problems with the finance application and can increase the client's costs through having to rectify the spelling on the contract or having the original contract rescinded and a replacement one entered into. So, get the name right, guys.
Hi, Ross.
Hi, Ross.
Take the Emily.
Take thee, Rachel. Emily.
A buyer should also consider how they wish to purchase a property before they sign a contract, and it's best to take advice from their accountant or their solicitor before doing so, as amendment processes usually lead to added costs for the parties.
How do you explain it?
Made a mistake.
So did the hold-up man, and it happens to be the same mistake.
Another common error is failing to disclose encumbrances in the contract, which is shown on the title search for the property. These can include things affecting the property a buyer should know about, such as easements. Mortgages do not need to be disclosed to buyers. However, anything else that affects the property should be disclosed in this section. A simple title search, which costs approximately $25, will disclose this information and can then also be used to ensure that the seller's details and the property description are correct. This ensures certainty in the contract and also ensures that the buyer is not given any rights to terminate under the standard conditions for the seller's failure to disclose these items.
That's a fart in a stiff wind. My client proposes a 30-day cooling off period. My client feels sufficiently dispassionate. My client asks that you not initiate proceedings pending his setting certain affairs in order.
From time to time, we still see contracts that are missing the Panda 30C warning statements from the front. Panda bear, what the hell's a panda? And by way of quick refresher, the correct sequence for the contract documentation is: number 1, letter or statement directing the buyer's attention to the Form 30C warning statement. Number 2, the Form 30C warning statement. Number 3, the contract. Number 4, the Form 14 disclosure notice for community title scheme property. If the buyer does not receive the warning statement, then they may have rights at any time leading up to settlement to terminate the contract. So there you have it. Watch out for these common mistakes in your next property contract. Help us out by clicking subscribe to our YouTube channel and then share these tips on Facebook and by email. See you next time, guys.